Hello and welcome to Training on Workplace Harassment. All of us deserve to work in an environment free of harassment. However, the significant number of complaints of harassment filed every year proves this is still a problem. In this short presentation, I'll explain to you how to recognize unlawful workplace harassment and what you, an employee, should do if you are a victim of harassment. Before I go further, let me clarify something. I will explain protections under the federal EEO laws enforced by the U.S. Equal Employment Opportunity Commission, the EEOC. These laws apply to all employers with 15 or more employees and all federal employees. However, your state may have anti-discrimination employment laws that include additional protections that also apply to you and others in your state. Let's show you a real-life scenario of harassment in the workplace, and like all the examples you'll see today, it's drawn from actual cases.
Hey man, check it out.
Oh man, look at her.
Right, you know what I would do to her. I'm gonna take a picture for later.
Yeah, do that.
Why
Send it to
don't
me.
you take a picture? It'll last longer.
I already took two. Come on, man.
So let's start with the definition. Unlawful workplace harassment is unwelcome verbal or physical conduct that is based on one of the protected EEO bases that it alters the conditions of the victim's employment. This unwelcome harassment can change the conditions of employment in two ways. Number one, by being so objectively offensive, intimidating, hostile, or abusive that it effectively changes the terms and conditions of the workplace. Or, number two, by culminating in an employment action such as termination or demotion. Here are examples that could be part of workplace harassment. A man touching a woman inappropriately.
What do you think you're doing?
Relax, this is one little piece.
You're disgusting.
Come on, sweetheart, I'm just kidding.
Anti-Islamic cartoons sent to coworkers by email. Racial slurs painted on a wall or victim's car. And derogatory comments made about an employee's physical disability.
Hey, look. Larry, the trouble.
Please don't call me names. It's demeaning.
To help you understand the definition, let's discuss the phrases unwelcome conduct, protected EEO bases, and alter the conditions of the victim's employment. Unwelcome conduct is conduct that you did not initiate and you find undesirable or offensive. For example, the reactions of the woman in the break room vignette showed that she was offended by the behavior of the men. Unwelcomeness depends on how it is received. Some employees, however, enjoy engaging in harmless sexual banter, dating, or even exchanging sexual jokes at work. This conduct may not be unwelcome if it is okay with everyone involved. Another example might be two coworkers who like to debate religion while on their breaks. Again, this may not be unwelcome if it's okay with both employees. Nonetheless, your employer is responsible for everyone's work environment. So, even if the two coworkers are having a private conversation and both are fine with the topic, that doesn't mean everyone else is okay with it. If you are offended by the sexual banter or religious discussions you overhear from your coworkers, their actions could be creating a hostile work environment for you. However, if you decide to join in, you can't later complain about being harassed because your actions indicated that you did not find your coworkers' conduct unwelcome. I also want to discuss how to communicate unwelcomeness. Merely saying something like, "I don't like that joke," may be enough. You can also communicate unwelcomeness by letting your supervisor know or by going to the person identified in your employer's anti-harassment policy. When most people hear the word harassment, they think of sexual harassment. The men's behavior in the break room vignette might be the beginning of sexual harassment that eventually creates a hostile work environment. Sex is one of the protected EEO bases. So, for now, let's just focus on sex harassment. Conduct does not have to be sexual to be based on sex. Sometimes it's about gender. For example, a woman who refers to all of her male employees as cavemen, or repeatedly tells them how men are inferior to women may be harassing them, but not in a sexual way. Jokes emailed around the office about women being unable to read a map or unable to properly park cars would be based on gender, but are not sexual in nature. Or when employees bully a coworker and call her names because she is transgender. This may be harassment based on gender, even though it is not sexual. So harassment based on sex includes both harassment that is sexual and harassment that is non-sexual and based on gender. Did you also know that both the victim and the harasser can be either a woman or a man? And the victim and harasser can be the same sex? Yes, men can harass women or men, and women can harass men or women. This goes for both sexual and gender-based harassment. But remember, harassment can be based on any of the protected bases. You should not ridicule, irritate, or mistreat another person because of his or her sex or gender, race, color, religion, national origin, age, 40 or older, genetic information, or disability. So what is considered the workplace? The workplace is essentially wherever you are working, not just the physical space where you work. For example, while on a business trip, a company's attorney makes sexual innuendos about her male assistant, quote, taking care of her needs, and refers to him as her boy toy. He is embarrassed and offended by these comments and references. So, this could be workplace harassment, even though this is happening outside of their actual work site. Your workplace can extend to anywhere you might travel for work, for a conference, or trade fair, or even at a local restaurant where an employee's retirement celebration is held. And absolutely anyone who has access to your workplace can be considered a harasser. This means your supervisor, a supervisor from another area, a coworker, or even non-employees like the guy who repairs the copier, the woman who delivers the mail, or one of the folks who clean your office windows could be a harasser. We've covered the first part of our definition. What is unwelcome conduct? And we've talked about the protected EEO bases. Now let's talk about the third phase in our definition, alter the conditions of the victim's employment. A hostile work environment is created if there are comments or conduct that is unwelcome and so severe or pervasive that it creates an intimidating or abusive environment for you or others. So, what is meant by severe or pervasive? First, let's look at conduct that is severe. Conduct that is severe is so serious or harmful that it may only need to happen once to create a hostile work environment. Physical touching escalates the severity of any given situation. Other examples of severe conduct include highly charged words and symbols in the workplace, like a hangman's noose, or a swastika painted on the wall, or use of the N-word. In general, the more severe the conduct, the less pervasive it needs to be to create a hostile work environment. So what do we mean by conduct that is pervasive? Pervasive means the conduct occurs on a regular basis. That's why some harassment, such as jokes, may not be initially considered severe, but when it occurs over and over again, it can become more than just inappropriate. It can be considered pervasive. The conduct by the men in the break room vignette occurred once. However, if the men in the opening vignette often made sexually suggestive gestures towards their coworker when they saw her or passed her in the hallway, then the frequency of their conduct could create a hostile work environment for her. Occasional teasing, offhand comments, or isolated incidents that are not serious may not be considered unlawful harassment. But the more often this type of behavior occurs, the less severe it needs to be to create a hostile work environment. Harassment can come in different forms. You've probably heard of the term hostile work environment, but have you heard of the term tangible employment action? Anyone with access to your workplace can create a hostile work environment. A supervisor, a coworker, or a non-employee. But only a supervisor or someone with supervisory authority can make significant changes in the conditions of your employment. In other words, when unwelcome conduct results in a tangible employment action, such as denial of overtime, discipline, promotion, or termination, the harasser can only be someone with this kind of authority. For example, if your supervisor is pressuring you for dates or for sex and you keep saying no, he may be creating a hostile work environment for you. If your supervisor then punishes you for saying no by taking away your office space or denying you training, then he has taken a tangible employment action against you. And remember, it doesn't matter whether your supervisor is a man or a woman. Either way, no employee should have to put up with harassment or be punished for speaking up about it. So what are your responsibilities as an employee when it comes to unlawful workplace harassment? First, do you know if your employer has an anti-harassment policy? Most employers do. Find yours and read it. Secondly, you should avoid engaging in inappropriate behavior. What is inappropriate behavior? To start with, offensive conduct that is based on race, sex, color, religion, national origin, age, or disability is inappropriate. So, for example, when you start to make a joke about someone's age or forward one of those emails that talks about a woman in a derogatory manner, stop yourself. Next, if you believe you are a victim of harassment or witness harassment and have supervisory responsibility, take a look at your employer's policy and follow it. Typically, your first step to getting help is to alert an appropriate official. If you don't have any idea where to start, or you're just not sure or have questions, talk to someone in your HR or EEO office. Once alerted, it is then your employer's responsibility to take steps to investigate and stop harassment. Finally, commit to attending and participating in all training sessions provided by your employer regarding workplace harassment. It is your responsibility to stay informed. In this presentation, we've covered a massive amount of information in a short time. We defined unlawful employment harassment, talked about the bases covered by the EEO laws and how the workplace extends to wherever you are working, and discussed how harassment can affect the work environment or affect the conditions of employment for its victims. If you still have questions, we have lots of information about harassment on our website at www.eeoc.gov. That's eeoc.gov. Thank you for taking the time to learn more about workplace harassment, as working in an environment free of harassment is the right of every employee.